Welcome back to the deep dive. Really glad you could join us again as we try to unpack some complex topics and get right to the core ideas.
Hello. Yes, today we're diving into, well, a really fundamental area of criminal law, affirmative defenses. It's, a space where things can seem a bit fuzzy sometimes.
Yeah, the lines can definitely blur, but getting the distinctions clear is just so important, isn't it?
Absolutely essential. We're talking about situations that are different from, say, the prosecution just failing to prove their case.
Right, like they couldn't prove you were there or you didn't have the necessary intent. That's just saying you haven't made your case.
Exactly. Affirmative defenses kick in after the prosecution has technically proven all the elements of the crime. The act, the intent, it's all there.
So the defendant is essentially saying, okay, yes, I did it, but...
Precisely. But there was a good reason. Or, well, maybe not a good reason in the sense of being lawful, but an understandable one. They argue the action was permissible, or maybe excusable because of the specific circumstances.
So it operates outside the basic definition of the crime itself.
That's the key. It's about avoiding some kind of unjust harm, or maybe even promoting a common good.
And for this deep dive, we're incredibly fortunate to be working with materials provided for educational purposes by the University of London. We really appreciate them making these available.
Yes, a huge thank you to the University of London. And we should also mention this deep dive is brought to you by Sinorbit Academy, Sri Lanka.
And just to be crystal clear, this is purely for educational use. We're aiming to help you get to grips with these concepts.
Definitely. And if you are prepping for exams right now, we really hope this helps clarify things. Good luck.
So the mission today, navigate these key defenses: duress, duress of circumstances, necessity, and self-defense.
Understand how they relate, but crucially, how they differ. Because, they all involve acting under pressure or to avoid harm, so they can look similar at first glance.
Getting those differences down is vital. Let's start there. Why do they get confused, and how do we start pulling them apart?
Well, the core confusion stems from that idea of acting, because you had to avoid something bad happening. But the law asks, what bad thing? Who were you acting against? And was your action considered justified or merely excused?
Okay, justified versus excused. That sounds like a really important distinction. What's the difference?
It's fundamental. A justified action is considered lawful in the circumstances. You basically did the right thing, legally speaking. Think self-defense against an attacker.
Right.
An excused action, however, is still considered legally wrong. You shouldn't have done it, technically. But the law excuses you because of the extreme pressure you were under. It's like a concession to human weakness. Think duress.
Got it. Justified, lawful, excused, technically wrong, but understandable. The
Well,
material uses a great example, illustration 11.1, doesn't it?
it does, yeah. Really helpful. Imagine V threatens to kill V unless V helps beat up X. So V is under this immense threat from D.
Okay, serious situation. V has choices. What happens first?
Scenario 1. V is terrified, gives in, and beats up X. V has committed an assault against X who's innocent in all this.
So what defense could V raise?
Duress by threats. V was forced by D's threat. The action against X is wrong, but the law might excuse it due to that overwhelming pressure. So, duress. An excuse often involves victimizing an innocent. Remember that. Excuse. Innocent victim.
Okay. Scenario 2. V doesn't attack X. Instead, V turns and attacks D, the person making the threat.
Now, V might still face charges, but the defense is completely different. It's self-defense. V is using force against the wrongdoer, D.
And that's
That's seen as justified. A lawful response. So, self-defense, justified, action against the wrongdoer. Big difference.
huge difference. Okay, what if V doesn't attack anyone but just tries to get away? Say V jumps in a car and drives recklessly to escape D.
Now we're likely looking at duress of circumstances. V isn't obeying a direct command from D to commit that crime, dangerous driving, but the circumstances created by D's threat compel V to act illegally to escape.
Is that justified or excused?
Still an excuse. Again, it's a concession. The law understands you might break a traffic law, say, to save your life. It's often seen in cases where the resulting crime doesn't have a specific direct victim, like X in the first scenario, although we'll see it can. So, duress of circumstances. Excused. External threat forcing the action.
Okay, one more variation. V sees D about to attack X. V acts quickly, pushes X out of the way to save X from serious harm, but X falls and gets slightly hurt. V assaulted X, technically.
Right. Here, V acted against an innocent X, but the purpose was to prevent a much greater harm to X. This points towards necessity.
Justified or excused.
Often viewed as a justification. V chose the lesser of two evils to promote the greater good, saving X from serious injury. So, necessity, justification, lesser evil, common good.
Wow. Okay, so that one initial threat from D spins off into potentially 4 different defenses depending entirely on V's reaction. Duress, self-defense, duress of circumstances, necessity. And that justified excuse split is the key thread.
Absolutely. Keeping that distinction in mind really helps navigate these. Shall we dig into self-defense first?
Let's do it. The material grounds it in Section 3 of the Criminal Law Act, 1967.
Yes, that's the starting point. It allows reasonable force to prevent crime or assist in lawful arrest. And private defense protecting yourself, others, property that falls under this umbrella.
What are the requirements?
Yeah.
The force has to be defensive, right? Not revenge.
Exactly. It must be defensive, directed against someone posing an unjust threat, and used for the purpose of resisting that threat or preventing crime. Retaliation is out.
Like that taxi driver case, Wilkinson. Detaining someone for not paying wasn't preventing a crime that was happening then.
Right, it was seen as retaliatory. Same with Demario Williams trying to get back property after it was stolen wasn't preventing the theft. It has to be about an ongoing or imminent threat.
And it has to be an unjust threat, so you can't resist a lawful arrest.
Correct. Or use it against someone innocent, like X in our earlier example, or the weaker twin in the Rate A case. If you harm an innocent party under threat, you're looking at duress, or possibly necessity, not self-defense.
Okay. Now, a lot of this is codified now, isn't it? Section 76 of the Criminal Justice and Immigration Act, 2008.
Yes, Section 76, as amended in 2013, largely puts the common law principles onto a statutory footing, and it contains some absolutely crucial points.
Particularly subsection 3 and 4 about the defendant's belief.
Yes, this is vital. The reasonableness of the force used is judged based on the circumstances as the defendant genuinely believed them to be. Let that sink in.
So even if you're mistaken about the threat?
Even if you're mistaken, subsection 4 goes further. Even if your mistaken belief was unreasonable, you can still rely on it if the jury accepts you genuinely held that belief. Your unreasonableness is just evidence that might make the jury doubt you really believed it, but it doesn't automatically kill the defense if they think your belief was genuine.
That's the Beckford principle, isn't it? The defendant thought he was being shot at.
Exactly. The question for the jury was, did he honestly believe that? And was the force he used proportionate to that belief? Genuine belief is the key here for the need to use force. Repeat that. Genuine belief is key.
Are there limits to that?
Oh, yes. Important ones. If your mistaken belief stems from an insane delusion, the correct defense is insanity, not self-defense. That was the Oye case.
And intoxication.
Big one. Section 765 is clear. You cannot rely on a mistaken belief resulting from voluntary intoxication. So if you're drunk and think someone's attacking you when they're not, tough luck on the self-defense front.
Even if it's a drug-induced psychosis, like in Taj.
Yes, Taj confirmed that even a temporary psychotic state from recent voluntary drug use counts. No self-defense based on that mistaken belief. Repeat. No defense if mistake from voluntary intoxication.
Okay, so genuine belief matters for the need for force unless you're voluntarily intoxicated or insane. What about the amount of force, the reasonable force part?
Right. Section 7666 says force isn't reasonable if it was disproportionate. What's disproportionate depends entirely on the circumstances, the level of the threat.
So context is everything. Petrol bombs against rioters in AG's reference No. 2 of 1983, proportionate.
But shooting a fleeing burglar in Martin, Anthony, disproportionate. Unless maybe the burglar posed an immediate lethal threat.
Or shooting at a car that's already driven past, like the soldier in Clegg, disproportionate danger over.
Precisely. But then there's the householder exception, Section 765A. This is important.
Right, brought in by the Crime and Courts Act 2013. This changes things for people defending themselves in their homes.
It does. For a householder facing an intruder, force isn't automatically unreasonable just because it's disproportionate. It only becomes unreasonable if it's grossly disproportionate.
So disproportionate might be okay, but grossly disproportionate is not. That gives householders more latitude. Repeat. Disproportionate, okay. Grossly disproportionate, not okay for householders.
Exactly. It's still a high bar, grossly disproportionate, serious level of force, but it acknowledges the unique vulnerability someone might feel in their own home.
The courts also give guidance on assessing reasonableness generally, right? Like the force has to be necessary at that moment.
Yes, immediately necessary based on the facts as D believed them. If you had another safer option, locking a door, calling police with time to spare, using force might be seen as unreasonable.
But you don't have to run away. There's no duty to retreat.
Correct. No duty to retreat. That was confirmed in Field. You're entitled to stand your ground if attacked. Repeat. No duty to retreat.
What if you kind of started it? Provoked the attack?
That doesn't automatically rule out self-defense. If you provoke someone but their response is way over the top and your force is then proportionate to their excessive reaction, you might still have the defense. That's Rashford. Repeat. Provoking attack doesn't mean you lose the defense if the response is excessive.
Could you strike first?
Yes, a preemptive strike is allowed if you honestly and genuinely believe an attack is imminent. You don't have to wait for the blow to land. Lord Griffith in Beckford was clear on that. Repeat. Preemptive strike allowed for imminent threat.
Okay, so the need for force is subjective based on D's belief. But the amount of force, its reasonableness, is that subjective too?
No, and this is crucial. While we consider the circumstances as D believed them, the question of whether the degree of force used was reasonable or proportionate is ultimately decided objectively by the jury. Repeat. Objective test for reasonableness of force.
Even though the law acknowledges people act under stress, the Palmer quote about detached reflection not being possible.
Yes, Section 767 explicitly tells the jury to consider that. Acting instinctively in the moment is strong evidence the force was reasonable. But it doesn't completely override the objective standard of proportionality.
So that's why Clegg and Martin, Anthony, were convicted. Even if they genuinely felt scared, the force they used was objectively deemed too much for the situation, either because the danger had passed or the threat wasn't that severe.
Exactly. Objective reasonableness acts as a backstop, and Yaman hitting a locksmith with a hammer, even mistakenly believing him a burglar, objectively excessive force.
And back to the householder rule. Cases like Collins and Ray clarify. Grossly disproportionate force is always unlawful. But if it's just disproportionate, but not grossly so, it might be reasonable, and it's up to the jury to decide based on everything. Repeat. Householder protection allows disproportionate force, if not gross, if jury finds it reasonable.
And Section 76, 8b, makes clear householders can include places like shops where people also live.
Scope-wise, self-defense is pretty broad. It can apply even to a murder charge.
Yes, it's a defense to crimes involving force, including murder, which does create some tension, particularly with police shootings in the European Convention on Human Rights, Article 2.
How so?
Well, Article 2 says lethal force must be absolutely necessary. Our law, with Section 76 focusing on honest belief, might acquit someone who killed based on a genuine but mistaken belief, like thinking a phone was a gun, even though objectively the killing wasn't absolutely necessary. There is a potential clash there.
Interesting. And it generally doesn't apply to crimes that don't involve force used defensively?
Right. Your basic driving offense, theft, fraud, probably no self-defense unless force was used as part of the defense. Driving away from a threat would usually be duress of circumstances.
But didn't R.V. Riddell have a driving offense where self-defense did apply?
Yes. Good point. In Riddell, the defendant actually used their car as force nudging the pursuing car. Because force was used defensively, self-defense was potentially available for the resulting dangerous driving charge. Shows the act matters. Repeat, driving offense can be self-defense if force is used.
Okay, that clarifies self-defense nicely. Let's switch gears to duress, threats, and circumstances. This is an excuse, right? A concession to human frailty.
Exactly. You did wrong, but under immense pressure. The classic test from Whelan is key here. Repeat, Whelan test immediate death or serious violence, overbear ordinary resistance.
And we saw the two forms earlier. Duress by threats, coerced by a person, and duress of circumstances, compelled by the situation.
Yes. Illustration 11.2 showed that while taxi driver forced to speed by a gunman, threats, versus speeding through a red light to avoid a crash, circumstances.
The basic test for both comes from Graham, doesn't it? And it was endorsed in Howe and applied to circumstances in Martin.
Correct. The two-stage Graham test. First, did the defendant reasonably believe they faced a threat of death or serious injury? Second, would a sober person of reasonable firmness, sharing the defendant's relevant characteristics, have acted the same way? Repeat, Graham test belief plus objective response.
Okay, reasonable firmness. What characteristics count?
Age, sex, pregnancy, recognized physical or mental disability, those can be considered, Bowen. Even things like learned helplessness from trauma, Sewell.
But not just being timid or less intelligent.
No, the standard isn't lowered for general cowardice or low IQ, Hegarty, Bowen. It's an objective standard of courage, albeit one that can be contextualized by certain characteristics. Repeat. Objective standard of courage, but some characteristics matter.
Now, Hassan, this case really laid down some strict limits on duress, didn't it? Lord Bingham's points.
Absolutely critical.
No.
7 key restrictions from Hassan. You really need to know these.
Okay, point 1.
The threat must be of death or serious injury, GBH, nothing less. Threats of revealing secrets, Valderrama Vega, or causing pain, Quayle, don't count. Though Obeder in A, RJ, suggested a credible threat of rape might suffice. Repeat, death or serious injury, GBH.
Point 2. Who must the threat be against?
D, immediate family or someone D reasonably feels responsible for. Hassan was narrow, but Lord Wolf's view and Shaler, anyone you feel responsible for, like people in a building you know has a bomb threat, is often preferred. Repeat, threat must be to self or someone for whom D is responsible.
Point 3. Objectivity.
Yes, the tests are objective. Crucially, any mistaken belief about the threat must be reasonable. This is a key difference from self-defense. Repeat, mistaken belief must be reasonable in duress, unlike self-defense. The court also objectively balances the threat against the crime committed, Abdul Hussein.
Point 4. Causation.
The crime must be directly caused by the threats. If D had other reasons and might have done it anyway, no defense. Valderrama Vega again. Repeat, crime must be directly caused by the threat.
Point 5.
Huge one. No defense if D had a reasonable opportunity to escape or seek police help. Gill. And Hassan really tightened this, overruling Hudson and Taylor. The threat must be immediate or almost immediate to constrain D's will. Repeat. Hassan requires immediate or almost immediate threat, no defense if evasive action possible.
That immediacy requirement seems quite tough.
It is,
Yeah.
and it raises questions about how it fits with considering D's characteristics when judging if escape was truly possible for them.
Okay, point 6. Prior fault. Putting yourself in that position.
Right. 2 aspects. First, voluntary intoxication is disregarded when assessing D's courage, Graham. Second, if you voluntarily associate with criminals, knowing or reasonably foreseeing you might be pressured into crime, you lose the defense. Joining a gang, Sharp. Associating with drug dealers, Heath Mullally. Or just knowing coercion is a risk, Hassan. Repeat. No defense if you voluntarily expose yourself to risk of coercion.
And finally, point 7. The scope. What crimes does duress not cover?
Some treasons, and critically, murder and attempted murder. Repeat. No defense to murder or attempted murder.
That wasn't always the rule for accessories, was it? Lynch.
Correct. Lynch allowed it for an accessory, focusing on human frailty. But Howe firmly overruled Lynch, stating duress is no defense to murder for anyone, principal or accessory. It stressed the moral argument about the sanctity of innocent life, drawing on Dudley and Stevens. Repeat, Lynch overruled by Howe, no duress for murder.
And Gotts extended that to attempted murder.
Yes. But interestingly, Ness confirmed duress is still a defense to conspiracy to murder.
So you can be excused for agreeing to murder under duress, but not for trying or succeeding. That seems like a fine line.
It is. It raises those tough questions. Which argument wins? Human frailty or sanctity of life? Is it fair to treat accessories like principals under duress? What if you only intend GBH under duress, but the victim dies? Lots to think about there.
Moving to duress of circumstances specifically, it grew out of driving cases initially.
Yes. Cases like Willer and Conway where drivers felt compelled to drive dangerously to escape threats. Conway, importantly, allowed for a reasonable mistake about the threat.
And Martin confirmed it as a distinct defense, where the threat isn't necessarily a person's demand, like the wife threatening suicide.
Exactly. And it's expanded beyond driving pommel involved possessing a gun briefly to prevent harm.
Does it only apply to victimless crimes?
Mostly, but not exclusively. Petgrave confirmed it could apply even if an innocent was harmed, like a pedestrian injured by someone driving dangerously under duress of circumstances. Repeat, can apply even if an innocent person is injured. Petgrave.
And conceptually, it seems to be drifting towards necessity. Less excuse, more justification.
There's definitely a trend that way, seeing it more as choosing the lesser of two evils, which is the language of necessity.
So let's tackle necessity itself. Broadly, it's about acting unlawfully, either excused by an emergency or justified by pursuing a greater good. That's from Perka v. Queen.
Yes, that captures the two strands. Necessity as an excuse overlaps a lot with duress of circumstances, but its scope has been really restricted, especially since Dudley and Stevens.
The shipwrecked sailor's case.
Yeah.
Killing the cabin boy to survive.
That's the one. The court famously rejected necessity as a defense to murder there. And that principle heavily influenced Howe in denying duress for murder, too. Repeat. Dudley and Stevens rejected necessity for killing an innocent.
Why have the courts been so reluctant to embrace a general necessity defense?
Fear of chaos, really. Could people claim necessity to justify theft due to poverty or homelessness? Lord Denning's famous door which no man could shut, quote, in Southwark LBC v. Williams, sums up that floodgates concern. Repeat. Lord Denning's famous floodgates warning?
Duress of circumstances offers a partial solution, being limited to immediate emergencies, threats of death, serious injury, no real choice.
Exactly. It cabins the excuse to situations where D truly feels they have no alternative. It limits the floodgates.
But necessity as a justification that has gained more acceptance, particularly in medicine.
Yes, definitely. Cases involving medical treatment for those unable to consent. Re-F is key here.
Sterilizing a mentally incompetent patient.
Yes, justified based on her best interests. Lord Gough explicitly framed it as a justification principle, not limited to emergencies. Routine care could fall under it. Repeat. Necessity as justification recognized in medical context, Re-F.
But it can't override a competent patient's refusal.
Absolutely not. St. George's V.S. Re-C, a competent adult's wishes are paramount, even if refusing life-saving treatment. Repeat. Cannot override competent patient's refusal.
Which brings us to the really tough case, Re-A, the conjoined twins.
Yes, a landmark. Necessity was used to justify separating the twins, knowing one, Mary, would inevitably die in order to save the other, Jody, who could live a relatively normal life but would die if they remained joined. Duress wasn't available for murder, so justification was the only route. Repeat. Repeat around. A necessity as justification for separating twins, saving one life where the other was doomed.
Brooke L.J. set out principles for this justification.
He did. 3 key conditions. 1. The act avoids inevitable and irreparable evil. 2. No more is done than reasonably necessary for the purpose. 3. The evil inflicted is not disproportionate to the evil avoided. Repeat. Brooke L.J.'s 3 principles for necessity justification.
It feels unique because Mary's death was a side effect of saving Jody, not the means to save Jody.
That's a crucial distinction often drawn. It wasn't like taking Mary's organs to save Jody. This distinction might limit Rie's application outside very specific medical or similar contexts where death is an unavoidable consequence of saving another life.
Still, it opens up mind-bending scenarios. Pushing someone off a ledge to save yourself from a falling object.
Yeah.
Sacrificing one hostage to save many. Where does necessity stop?
Exactly. It pushes right up against the Dudley and Stevens principle and forces us to constantly reevaluate the balance between justification and the absolute value of innocent life.
Okay, a whirlwind tour. Let's try a quick recap to pull it all together. 4 defenses.
Right, self-defense, usually a justification. Against a wrongdoer, force needs to be reasonable based on D's genuine belief, even if unreasonable, unless drunk insane. Objective test for amount of force, proportionality with householder rule, covers murder.
Duress. Threat circumstances. An excuse. Responding to threat of death, serious injury. Threat must be immediate, almost immediate, Hassan. Mistaken belief must be reasonable, not a defense to murder, attempted murder.
Duress of circumstances, subset of duress, an excuse, compelled by situation, uses Graham test, Hassan restrictions apply, can apply even if innocence harmed, Petgrave, blurs into necessity.
Necessity can be excused, like duress of circs or justification, intellical rie. Justification needs inevitable evil, proportionate action. Brooke L.J.'s test. Limited scope historically, Dudley, floodgates. Can't override competent refusal.
Key takeaways, justified versus excused. Different standards for mistaken belief. Self-defense genuine, duress reasonable. Scope differences, a spate of murder. Immediacy rule in Hassan for duress. Remember the key cases. Beckford, Graham, Howe, Hassan, Rie, Dudley, and Stevens. And the statutes. SB 3 CLA, 1967, S.76, CJIA, 2008.
Getting those distinctions, cases, and rules straight is absolutely crucial, especially if you're facing exams on this. Reviewing these points should really help.
We certainly hope so. Good luck again with all your studies.
This deep dive into affirmative defenses was brought to you by Sinorbit Academy, Sri Lanka, and we thank the University of London again for making their excellent educational materials available.
Thanks for joining us.
And here's something to mull over. We've talked about these fine legal lines, disproportionate versus grossly disproportionate force, a reasonable versus an unreasonable but genuine belief, the agonizing choice in Rie. Considering all that, just how immense is the pressure on someone actually in that split-second terrifying situation, knowing their actions will later be judged against these complex standards?
It really highlights the gap between immediate survival instinct and considered legal analysis, doesn't it?
Definitely something to keep thinking about. Thanks again for joining us on The Deep Dive.